Good afternoon, and welcome to this Rappaport Forum. The HLS Rappaport Forum was launched in 2020 to promote full, open, and vigorous discussion. It is a respectful clash of ideas about critical and complicated issues that face our community, our nation, and our world. And I think we can all agree that there's no shortage of those issues today. This forum is made possible through the generous gift of the Rappaport Foundation, for which we are extremely grateful. And it builds on the legacy of the Harvard Law School Forum, which Jerry Rappaport founded in the wake of the Second World War to provide aspiring lawyers with regular opportunities to engage with ideas and issues and concerns connected to the study of law and to a rapidly changing world. Jerry Rappaport passed away in 2021, but his many contributions to Harvard Law School and to American life will live on for generations to come. I want to acknowledge and thank Jerry and Phyllis Rappaport and the Foundation for so many decades of support for Harvard Law School, for their commitment to civic discourse, and particularly for their generosity for which many generations of Harvard Law School students, faculty, and alumni continue to benefit. It is a delight to be moderating this session of the Rappaport Forum. Almost a year ago, on November 30th, 2022, to be precise, OpenAI released ChatGPT, a generative AI system that has since taken the world by storm. One of the most immediate areas of impact legally is, of course, the copyright system. Existing foundation models are trained on copyrighted material. Deploying using those models can pose and does pose many legal and ethical risks, particularly when creators fail to give attribution or compensation, much less seek for permission. In the United States and in several other countries, copyrighted content may be used to build these foundation models. And in some countries like the US, the fair use doctrine provides some shield, arguably. We'll hear about that this afternoon. And then, of course, there's the question of who owns what the AI system produces, who should be paid for it, and the kinds of questions that affect whether or not infringement ought to attach, to whom it ought to attach, and how we judge the merits of this new technology. I think it's important, and certainly all of our copyright students here know that copyright is, fair use is not a guarantee, and in fact, when we talk about artificial intelligence and particularly generative AI, we're talking about not one product, but many, from systems that allow you to create art, music, generate code, and those that simply tell you the next version of your favorite story. Our panelists today are well-known and leading copyright scholars. Professor Justin Hughes is the Honorable William Matthew Byrne, Junior Distinguished Professor of Law at Loyola Law School. Prior to joining Loyola in 2013, Professor Hughes taught at Cardozo Law School, where he served as director of the school's intellectual property program. And through 2008, he also founded the law school's Indie Film Clinic, which was the first of its kind. From 2009 through 2013, Professor Hughes worked in the Obama administration as senior advisor to the Undersecretary of Commerce for Intellectual Property. In that capacity, he was the U.S. chief negotiator for the Beijing Treaty on Audiovisual Performances in 2012 and the Marrakesh Treaty for the Blind in 2013, where we had the joy of working together. No one knew that international negotiations would be set by law professors' teaching schedules. In the 1990s, Professor Hughes did volunteer work in democracy development in Latin America, West Africa, and the Balkans. He has practiced law in Paris and Los Angeles. As a Henry Luce Scholar, he clerked for the Lord President of the Malaysian Supreme Court in Kuala Lumpur. He is a visiting professor on the Faculty of Law at Oxford And while he hasn't written a lot yet on IP and AI, when a DC district court recently ruled that the Copyright Office was correct in saying that AI-generated work cannot be copyrighted, the case of Thaler versus Perlmutter, the only scholar that they cited was Justin. And in fact, all the cases cited by the court came from one of his law review articles. So we are really delighted to have Justin here, who is an HLS grad and a dear friend. Professor Pamela Samuelson probably needs no introduction. I am extremely pleased and proud to say that she is one of my mentors and teachers and has guided me almost my entire career, both reading my drafts and giving me critical scholarly advice and career development counsel. She is the Richard M. Sherman Distinguished Professor of Law and Information at the University of California, Berkeley. She is recognized as a pioneer in digital copyright law and in intellectual property and cyber law, and is a joint appointee at the UC Berkeley School of Information. She is the director of the internationally renowned Berkeley Center for Law and Technology and co-founder and chair of the Board of Authors Alliance, a nonprofit organization that promotes the public interest in access to knowledge. She's on the board of EFF, Electronic Frontier Foundation, and on many advisory boards. She began her legal career as an associate with Wilkie Farr and Gallagher in New York, and is one of the pioneering scholars really writing at the interface of copyright law and computer science. She was named an honorary professor at the University of Amsterdam in 2002. She's written and published extensively in the areas of copyright, software, and cyber law. She has been a contributing editor of communications of the ACM, which is a computing professionals journal, and she has written more than 70 columns there. She, from 1997 through 2002, was a fellow of the John D. and Catherine MacArthur Foundation and a fellow of the ACM. The Anita Borg Institute recently honored her with its Women of Vision Award for Social Impact, and Public Knowledge awarded her its IP3 Award for its contributions in internet law and policy. So, Professor Samuelson and Professor Hughes, we're going to begin our conversation this afternoon. I'm going to ask the question, because you both have been involved in so much of copyright reform work. What is new about AI with respect to copyright? Why is this just not another wave of what we saw with the internet? And Pam, I'm going to start with you.
So there have been disruptive technologies before, and sometimes they've been subject to lawsuits. This is not entirely new. Player pianos, makers of player piano rolls were actually sued because they hadn't cleared rights to make the music, and the Supreme Court basically said, it's a piano roll, doesn't look like sheet music to me. And so that was an early one. Photocopy machines, they were the bane of publishers' existence for a while. Home taping, going to devastate the sound recording industry. And colorfully, Jack Valenti talked about the Betamax machine to American film producers and the public as a threat, like the Boston Strangler to a woman alone, okay? And so we've kind of been through kind of moral panics about new technologies in the past, and I think it's actually helpful to sort of put in context this. So what is different about this is that the Betamax machines, the photocopy machines, and others basically made copies of whatever it was that the content was, okay? And the reason it seemed like it was an infringement was because it kind of substituted for buying one. What's new about this is that, for the most part, the outputs of generative AI don't make exact copies, don't make near copies. Most of the outputs, in fact, are not substantially similar, and that's going to pose some issues for courts as they try to think about these things. I think it's also important to put generative AI in this context, which is that usually it's only the recording industry or the motion picture industry or the publishers who are upset. Now everybody's upset because all kinds of digital data is useful for training these models. And so it's also disruptive in a whole bunch of other ways. And so we just saw today, actually the White House issued an executive order, 100 pages long, listing all kinds of concerns about the disruptions that AI technologies are causing, and safety and defamation and disinformation and blah, 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 privacy, blah, blah, blah. So these lawsuits that are in place are only about copyright. And one of the things that I'm concerned about is that people that are kind of in a moral panic right now about also job displacement, right? Goldman Sachs published a report saying that generative AI is going to displace 300 million jobs. And you kind of go, oh, man. That's one of the concerns of that's driving some of the lawsuits that we're talking about. But lawyers and accountants and administrators are in much more likely to get displaced than authors and artists, in my view. But I think we have now more than a dozen generative AI copyright lawsuits before the courts. And I think before we kind of delve into fair use defenses and the like, just a quick overview of a couple of concepts, especially about how generative AI systems are developed and how they generate output, because it's really easy to say, oh, here's the training data that includes these copyrighted works, and here's some outputs. Those outputs must be copies, and the model must have copies of the data on which it was trained, and that's just not true. Or at least it's not true in the way that copyright law thinks about them, right? So essentially, the steps that go into the development and deployment of these systems are first gathering large quantities of information. Much of the information is available on the open internet. Most of the training is done with data from the open internet. And once you kind of have say, a common crawl data set, then you kind of like curate it. You throw out some stuff that you don't want to be. And so deduplication, for example, taking out multiple copies of things so that the model doesn't memorize, learn to sort of reproduce that particular stuff. So you basically then curate the training set for whatever it is that you're trying to do, whether it's computer code, whether it's text, whether it's images. And then once you have curated the data, then you basically use it to train the model. So you have like an architecture that you are working with. You have training algorithms, and you run for the most part, it's an automated process. But what happens is that for each word, for example, in a text, the model will basically assign a token to that particular thing. And those tokens basically end up where other tokens like them live. And so what you have then is a kind of disassembly of the data on which the stuff is trained, and kind of an effort to understand through statistical modeling kind of what things tend to be next to what things and what things tend to be not next to things. And so you basically then create these kind of clusters, really, of here's the cats and here's the dogs for an image generator. And so it's no particular dog from any particular work. It's just things that these models get trained on to produce representations in numbers. And that's actually a thing that we kind of like find difficult to parse, but there's lots of explanatory material out there. So I just want to say then, what you have is a trained model, and they fine-tune it very often to kind of make sure that it's aligned with whatever the purpose of the system is. And then they deploy it, and then people sign up, or it gets deployed either in-house. Many generative AI systems are being done in-house, or it may be done with businesses, or it may be done, as ChatGPT does, with ordinary consumers. So that's the kind of the short version.
Let me see if Justin wants to jump in with thoughts about the training, because with AI, what we have are sort of three clusters of issues: the inputs, where is the data from, and there are lots of concerns about the data. So even if it's disassembled and curated, ultimately, there are still these concerns. So Justin, what are your thoughts? Pam, ultimately ends up with where the data is not as problematic, but obviously we start off with lots of debate about this.
Right. Well, I think Pam and I agree that the large language models themselves are not copies.
Yeah.
But if you're talking literally about violations of 106, the right of reproduction, the act of creating the large language model involves probably several steps of iterative copying. So if you are taking something like many of the large language models have been trained on Books 3. Books 3 itself was built from a shadow library of pirated copyright material, 191,000 books. So that itself was several acts of reproduction. Prima facie violation, we're not yet to fair use. And the image generating, to understand how that works, it's not hard to find. There's extensive reporting on the digital sweatshops around the world that have been operated in which images are taken off the internet, and they're useless to image generation for generative AI unless they're annotated. So you have to have someone annotating the image, producing a copy, and then producing a data set from which the model is trained. And our best speculation is that all the major companies keep copies of these training sets for various reasons. So while we agree that the LLM itself, while the model itself is not a copy, there certainly are many, many acts of copying that happen to get there.
Okay. Do you think that should be actionable copying? Because that's the question. I want you to pick up there, and then I'm going to come to Pam, because there's a lot of debate and disagreement in the literature about whether that act of gathering the data in the first place should be copying. And then secondly, the concern that it's hard to tell. Because all of these works are publicly available. They're getting them typically not behind paywalls, for a lot of the LLMs. So what do you do when there is in fact a breach of a paywall to extract that for copying? So you've got a couple of both sort of 1201, 1202 type problems, as well as just the act of copying.
Well, when you're talking about publicly available, lots is available on the dark internet, and it's publicly available, but it's not authorized.
Unauthorized.
So there's an awful lot of unauthorized that's publicly available. There's a whole line of scholarship everyone needs to know that basically says, well, this is a non-expressive use of the works, and so don't worry about it. It's non-expressive use of the works. And scholars, of course, many scholars would like to just push it over into concepts we already have. I think we should be ready for a complete rethink on everything, because one thing that happens in this conversation, listen to yourselves talking to it, read carefully about it, is this relentlessly anthropomorphic language. It learns, it trains, it remembers, it has a knowledge set, it has a knowledge base. Instead of trying to extract all that language from our discourse, maybe it's because we need to rethink what's happening. And if we do think it is learning, then I think it may be a kind of ingestion that is quasi-expressive. Okay. And so it's not simply on or off. Okay. Does that help?
All right. Pam?
So most of the data that these systems are trained on is actually available on the open internet and not pirate stuff, okay? So when we're talking about the types of data sets that the big sort of major developers are working with, we're talking about billions of copies of works, and sometimes in the trillions of parameters. And so while I think the shadow library issue is going to be one of the tough ones for the courts to deal with, and it's one of those things that I think it could go either way based on some of the precedents. But the courts have actually been pretty clear that if you are making copies of things in order to extract information, that's actually, and especially if then enable more things to happen with that information that advances the public interest, that actually is something which doesn't run afoul. And in terms of the training data sets, a big consideration has been whether the second work that's being used, the second use of the work, does it have the same purpose as the original? And so that's one of the things that the courts have decided should fall within the penumbra of transformative uses, which typically favor fair use. And what was the purpose of this author in writing this work in the first place? Well, it was to sell copies of their books. And what was the purpose of the use over here? It is to extract information and correlate statistical correlations between different things and make representations that enable then this productivity tool to develop. And as long as something has this transformative purpose, at least so far, the courts have been pretty supportive of fair use defenses, particularly when there isn't a likelihood of harm to the market. Now, let's say we're talking about the visual art for a minute. A lot of authors, a lot of artists put their works up on the internet so people can find them. So what harm has been done if Common Crawl basically makes copies of those? And there is in the European Union, for example, a special exception to copyright that allows the copying in order to engage in text and data mining. And generative AI is, in some sense, also a TDM type of utility. And courts have actually said that the plaintiffs say, but I'm willing to license this particular thing. And the courts basically say, that's speculative. There isn't really a viable market for this particular thing. And in the class action cases, most of the lawsuits that are pending are class actions. Mm-hmm. All of the authors of all the visual art in the world, they can't issue a license, right? It's not possible to issue a license.
But we could create institutions to do that. But Justin, I think, wants to jump in on this.
Well, so first of all, Pam is discussing everything in the framework of fair use and Section 107 of the Copyright Act. And I assume many of you are copyright students. Is that correct? Okay. And,
or they've engaged in fair use.
Okay. Well, because it's a large crowd, and I've been back to the law school a few times, but never had such a large crowd. So I assume it's the topic or the free lunch. But so Pam is engaging in the context of fair use and the fair use framework. And I think we would agree that we just don't know where it will come out, especially with something like the unauthorized access training data.
That's right.
The other part of this is it's not speculative about markets opening up, because when the content owners put up barriers, the AI companies are more than willing to pay. And they have already done a big licensing deal with Associated Press, and Associated Press was very careful about that and got most favored nation terms to say, if you do a better deal with the New York Times, which is also now preventing you from crawling, then I get that deal. So in terms of a market, the market actually is emerging, and the market is a market of technological features which prevent the crawlers, AI crawlers, from getting access to the content. And at that point, the multi-billion-dollar funded and invested AI companies are more than ready to pay. So I think in a fair use analysis, the longer they wait to litigate that, the worse it gets for the AI companies. But what is fair use is not necessarily what is fair or equitable. You are in a law school where we talk about fairness and justice. We talk about fairness and justice in terms of resources, natural resources, in terms of, in our world, intellectual property, traditional knowledge, access to genetic resources, use of traditional cultural expression and folklore. And if we have discussions about what is fair and equitable in that, where Western technological companies take from others, why aren't we having that discussion here, right? And so it's not just a question of, is it fair use or not, Section 107. It is and should be a larger social framework to me.
Well, so one of the things that has, in my sort of talking with judges across the country on this topic, two things are problematic, right? Copyright has never quite plainly been a tool for social justice, right? We've all, so this question you're raising about fair use has always been, okay, is it fair use? We haven't always asked the question, is it fair? Is this the sort of use that should be free? So Jane Ginsburg, for example, has always said, well, just pay for it. Why not just pay for it? So what sorts of uses should be free and what sorts of uses we should pay for has always been sort of a contested issue in copyright law. But I do want to ask the question, if not fair use, what? These are large language models. In order for the technology to advance, they need billions of data points. And I think, Pam, you said most famously that copyright could stop AI, bring AI to its knees, right? This is a famous Pam Samuelson quote. Yeah, which is also anthropomorphic, absolutely. So there are a number of things that are problematic, and I want to tease them out for our students and for our audience. First, fair use has always been intimately connected with the First Amendment. So to what extent, if we eliminate fair use as the major tool for facilitating access to the data and for the training materials, what are our options? What are the consequences? Pam?
Well, I think the question of how much fairness should count when we're doing a fair use analysis, I'm going to stick with that first because courts have viewed fair use as doing a lot of work that otherwise the First Amendment would do. And the courts frequently say that the whole point of fair use is to give some breathing space, right, for follow-on creations, because follow-on creations actually advance knowledge in the way that the constitutional purpose of copyright is supposed to be beneficial to the public and not just to the individual. And so this kind of larger context of copyright's public purpose is something which I think does accommodate to some degree, but not displace entirely First Amendment concerns. But on the social justice point, one of the reasons why the courts have been pretty skeptical, and the Supreme Court at least twice has basically said, we shouldn't actually ask whether this is in good faith or bad faith. We shouldn't consider like, is this really morally fair? Is because you don't want copyright litigation to turn into, here's the white hat and here's the black hat, and make it into a kind of morality play. It is already in many of the cases anyway. But what we want to do is we want to see, is the use that's being challenged actually promoting the public good? And how many of you here are ChatGPT users? You and 180 million other people are users of these technologies. There's probably some of you who use Midjourney too. There's only 17 million people who are users of that particular thing. But you have to understand that if these generative AI companies are infringers, then potentially all of the users are infringers too. And I don't think courts are going to necessarily think that's a really cool idea. So that was one of the reasons why the Supreme Court in the Sony Betamax case back in 1984 kind of backed off from the idea of saying that the Betamax machine was a contributory infringement of the television programs, even when you were just time shifting, okay? Now, that was a very close decision at the time, but the court, the lawyer for Sony stood up before the court and said, there are 9.5 million households in the United States that own a videotape recorder right now, and they're expecting to go up to 50 million by the end of the decade. And do you really want to say that all of the people who make copies, even for time-shifting purposes, are infringers? And I think the court was really quite reluctant to go there. And so it may be that, in fact, what we can say, courts will do some interesting things here, is say, there's some infringement over here on training data, but the model itself doesn't infringe because it doesn't contain expression from the underlying works, and therefore the model can go still, or the court could say, no, it's a fruit of the poisonous tree, and basically shut the whole thing down. And so there's huge amounts at stake in these cases, and the courts are really faced with a lot of different questions. They're pending in quite a few different courts now. There's one in Tennessee. There's at least one, maybe two in New York, and then Northern District, California, and Delaware. So we'll have lots of chances for circuit splits in this particular set
I
of
think we
cases.
have, what, about 11 cases now?
12.
Or 12?
Can
Justin, I want you to jump in, and I want to, because Pam has put a lot into into her response to this. And one question, obviously, whether generative AI and the Betamax, whether that's the appropriate kind of analogy. What happened with Napster, where you had lots and lots of users who did, in fact, become infringers. So let's have this fight. Go ahead, Justin.
Right. So, Pam tends to use analog cases that are helpful to her. And she does not like to use digital cases that are unhelpful to her, which are the cases of the peer-to-peer cases where the Supreme Court said, no, shut it down, and there were millions of users, or ABC v. Aereo, where the court said, no, shut it down, even though there were hundreds of thousands of users. First of all, Pam, the Supreme Court in Harper and Roe v. Nation said intent of the defendant does count. Bad faith counts.
Pam's like,
And the Supreme Court has never said that was wrong. So there's a lot of lower court precedent that says, yes, bad faith on the part of the intent of the defendant counts. Now, Pam said
They're
to
really
you,
good friends.
Pam
Let's
said to
be
you,
clear about this.
Pam said to you, this might slow things down, and there are huge amounts at stake in these cases. I say to you, you shouldn't care about the amounts at stake, because that's the deep pockets of Microsoft and Google, and you shouldn't care. Okay? What you should care about is what's best for all of us. A few months ago, Chuck Schumer announced the AI framework and the AI initiative in the Senate. And one of the things he said is, of course, in all this work, our North Star will be innovation. And I wanted to strangle him. Because our North Star is not innovation. Our North Star for a senator or the leader of the Senate is the welfare of the American people, not innovation. I am tired of this monolithic God innovation getting in the way of serious discussions about what's best for all of us. So last March, 1,000 scientists, researchers, and tech people signed a letter saying, let's put a pause on this. We need to put a pause on this.
Over 2,000 now.
Yeah, actually 33,000
33,000.
names. 33,000 people have signed a letter saying, let's put a 6-month pause on this and figure out what we're doing. So, you know, it's small potatoes. If the copyright system ended up costing them a few $1 billion and slowed them down a couple months, most of those researchers would say, oh, thank you. But I just don't think that pointing out how many people use ChatGPT is necessarily speaking to the common weal. because how many young people use Facebook, and yet we have 41 attorney generals suing Facebook saying they're using it because it's addictive and it hasn't made the world a better place. And in this very first Rappaport forum, which is wonderful and you should go back and listen to it, what the speakers agreed to was that Generation Z, millennials, are statistically more stressed out and more depressed than any generation before them, and it's because of social media. So the innovation that California, our home state, has been giving you is not always to everyone's benefit. And so I think if there's a pause, that's okay. But again, we shouldn't be talking about this just in the context of is it fair use or not, because Pam and I agree on that.
Pam
right?
wants to
It may or
respond.
may not be fair use.
So before Pam jumps in, because this is going to, and we're not going to, we will run out of time. I just want to put some things on the table before we do. The students all learn from Terry and from me, and you know, they've read and heard about your work in the course of our copyright teaching, and from Rebecca Tushnet. Copyright law at least purports to be morally neutral, as with most IP law. We do not ask the question, is this morally right or wrong? Historically, this has always been in the background, and certainly with patent law, this has been a question. But with copyright law, you can get a copyright on the most pernicious sort of, you know, negative welfare inducing work. Now, you may have other legal regimes that address the consequences, but copyright has never been sort of the site of regulation. But there is a concern here with AI systems. One, because of the digital sweatshops. I think authors are rightly concerned that they are involved with a global system in which people are essentially being treated like products or assets in order to generate the kind of data for AI systems. For those of you who haven't seen yet, people are still calculating what it costs just climate change impacts of developing these systems, very significant. And so fair use doesn't actually allow us to talk about some of these trade-offs that we're making in the name of innovation. So Pam, I do want you to respond, because you are one of the most staunch proponents of fair use that I know, and God help you if you oppose fair use, you will fall into the wrath of Pam. But Pam, I want you to address to this. Well, you know, I want you to respond to this, because there isn't a doctrine in copyright that would allow authors of the works that are being mined to have a say in the development and the shape of AI.
So I'm going to start with Justin, of course, and distinguish the peer-to-peer cases, Napster and Grokster. I didn't shed a tear for either of them when they lost, because they were, in fact, inducing a lot of infringement by people. But it's infringement because they were reproducing the exact copies, okay? What's different about the generative AI stuff is that it's generating output, but overwhelmingly the output that it generates, whether it's a plan for your garden, itinerary for a trip to Milan, or editing your footnotes for your law review article, okay? Those outputs are not infringing derivative works, okay? So the Napster Grokster, oh, the next Napster and the next Grokster is like, no, not really. And this idea that, you know, oh, we should slow down this stuff, okay? The people who are calling out for slowing down, number one, they knew that this was not going to happen, okay? It's like, yeah, right. But what they did do is they got the attention of a lot of policymakers. And so for the last 6, 8 months, whatever, people inside the White House have been working like crazy to generate this 100-page policy document. And people in Congress are introducing bills to like regulate regulate AI, and I have no objection to that. I just don't like copyright law to be used for non-copyright purposes, okay? And what I see in some of these lawsuits is, I want to destroy these models, right? I want an injunction. Impoundment and destruction are two of the remedies that have been in the copyright bundle for a long time, and some of them want just to destroy these things, okay? Now, there may be other reasons why they should be destroyed, whether it's because of labor issues or because of climate change or because of safety or privacy or whatever, okay? But you shouldn't be destroying the models because you're worried about privacy if in fact that's not what a copyright harm is here. So part of what we have, there are lots and lots of reasons why people bring copyright lawsuits when what they're really complaining about is something other than copyright infringement, right? They're using copyright claims to sort of vindicate another interest, and courts basically say, no, it has to be a harm of a sort that copyright law cares about. And that's going to be sort of a question about whether, in fact, we want to like expand what we consider to be a copyright harm. So the Authors Guild complaint basically says, you know, some of our authors are not getting as many jobs now because people are using ChatGPT instead of hiring me to do their work. And I'm going, well, you know, it is a productivity tool, right? And it has some beneficial uses. So as courts are trying to sort of grapple with, you have to like not only say, oh, well, these people are upset and these people think it should slow down, with, you know, what are people using it for, and what are the benefits of the system as well as the risk, and let's not just throw out the baby with the bathwater.
So I think we may have to have another forum on what counts as productivity. But I think Justin wants to jump in, and let me just sort of give you something because our time is fastly coming up here. But one challenge, of course, is this question whether creators and authors, copyright owners, in fact, ought to be paid, and under our statutory damages scheme. I think Pam's point is that if we use copyright, we can in fact shut down the innovation, whether you believe that or not. But because of statutory damages, this can be a pretty hefty club. So I guess I want to push you a little bit on her concern that this is not a copyright harm. But in the law, people use lots of different reasons to bring lawsuits. So why should copyright be different?
Well, I agree with both of you, and Pam is a copyright purist, and so she has a very clear vision of what copyright should be used for. But copyright lawsuits have been brought for all kinds of reasons, and you may or may not agree with that, depending on what your client needs, actually, as you get out there in the practice world. But I think we also agree that you have to draw a distinction between the inputs and the outputs. And Pam said that the inputs, we may have some finding of liability. The outputs, if you read these complaints, and I hope you have better things to do with your lives than read these complaints, but if you read these complaints, a lot of them say all the output is infringing derivative works. Pam and I would agree that's bullshit, right? It's just not true. Nonetheless, it is also not true to blithely, blanketly say most of the outputs will not be infringing. We just don't know. It really depends on the behavior of people, behavior of the users of the models, and it depends on the guardrails. You know, there is one image generator, I think it's maybe DALL-E that I played with, that if you say, I want to see Barack Obama naked in a bathtub, you won't get anything. But if you want to see Mickey Mouse in a Parisian cafe, you will get him. Okay, well,
I'll tell you. I know from the general counsel of OpenAI that was Midjourney, not DALL-E.
Okay, well, I can show you if you want to see Mickey in a Parisian
we do not want to
cafe
see. We do not want to see, but go ahead. Finish the point.
It got the wrong cafe, but it got a cafe. So, you know, what the outputs are, whether they're infringing or not, I think we'll agree most of it won't be infringing, but how much is infringing depends on behavior of users and depends on guardrails, which OpenAI can control. If OpenAI, this is not a programming issue. This is an end interface user. Pam and I would agree with that. You just say, you get Mickey Mouse, you just don't give results.
That's right.
And so those things are within the control of the tech people. One salutary effect of these lawsuits may be to force that discussion into the open and force some compromise between the two sides.
Who should own the copyright in the outputs?
This has actually been debated since the mid-1960s. Okay, I'm telling you this because I did research on this, and in fact, I wrote a paper on it.
You almost said I was there.
In 1985.
Stop it.
I wrote a paper on it in 1985, the last time it was hot. But at the time it was hot as a toy problem, right? Because there was no commercially valuable outputs that were being generated, and so it was kind of like, oh, the copyright lawyers like to talk about this thing. And the Office of Technology Assessment even wrote a big section of a report about AI-generated creations and what do we do about copyright. CONTU, the National Commission on New Technological Uses of Copyrighted Works, basically wrote a report about it too. So it was like a hot thing for a while, and now it's like real. And so it turns out that what was a toy problem is no longer a toy problem, and the Copyright Office is doing, I think, a lot of work to try to formulate a policy stance. And Justin, who was quoted in the opinion, has an opinion about this too.
Yeah.
Yes. Well, first of all, everyone should know that copyrighted works generated by computer-generated works are protected expressly under some copyright laws in the United Kingdom, in Ireland, in New Zealand. The United States, we have a position that it takes a natural person to generate a copyrighted work. I'm a little uncomfortable that we keep going down the road, we keep saying a human being, because I think we will live, maybe I won't, but you all will hopefully, live to a point where there are sentient things that are not human beings. And if it's sentient, it should be able to get a copyright. So I don't like the discourse about human beings. Only human beings can be authors. But we have a real issue, right, that unlike any other jurisdiction in the world, our Constitution says that we only give exclusive rights to authors. So we have to define what an author is. And that's not a problem in the UK or Ireland or New Zealand, so that's something we're going to have to figure out.
Yes, we do have.
But actually, they didn't use copyright. They made a copyright-like sui generis law for computer-generated works. This was back in 1988, the last time this stuff was hot.
Would that be constitutional to you?
Do we need a
think
constitutional amendment?
You know what? We're not going to get a constitutional
we're not.
amendment for that.
Do we need one?
No.
Okay.
They don't need incentives, these programs. The models don't need incentives. And if anybody needs incentives, maybe it's the person who generated the image or the text and wants to make use of it. A problem for the Copyright Office is they can't tell the difference between a human-created thing and a computer-generated thing. And so when they found out through social media that a person named Chris Castanova was bragging about getting copyright protection from the copyright
It was
registration.
It was Zaria the Dawn.
The Zaria of the Dawn.
Yeah.
She was bragging on social media that, hey, you know, I got a copyright, da, da, da. And the Copyright Office said, oh my God, and they canceled the registration and then had a new kind of proceeding and basically said, well, you can get copyright on the textual material that you did and on the selection and arrangement of the images that were generated by the computer. And just recently, they rejected a claim of copyright from an award-winning visual art image, because the person had used a bunch of prompts to bring it about, but the Copyright Office was not persuaded that the actual image that was that won the award was really human authored, and therefore rejected it. Not only do they say you can't claim copyright in this, but you must, if you register something that has AI generated stuff in it, you have to identify what's AI generated, and you have to disclaim authorship.
That's right. It's
And
got to
this
end
is
up in
going
the
to be
public domain.
very, very tricky for the, really, really tricky for the office to basically, because they can't tell the difference, okay? That's going to be really a trick. So if you don't tell them, they won't know.
But that's fraud on the Copyright Office. Don't do that.
Fraud on the Copyright Office.
That's fraud on the Copyright Office. We have a few minutes left for questions. We are actually ending this debate on a point that opens up the most divisive questions for us. Should sentient beings, whether they're human or not, be entitled to authorship status within the law? Should we use compulsory licensing as a model to get data, to get these language models trained? And more importantly, if someone says to a generative AI system, write me an administrative law review article like John Manning would write, does Dean Manning have a cause of action when that article spits out using idiosyncratic, things that the dean would put in his article, right? There are these questions about deep fakes and digital personality rights that are, so there are things that we're fighting about within copyright, but there are actually things that begin where copyright ends that historically we've ignored and that are going to be at the forefront, I think, of many of the debates that we have going forward. Let's get a couple of questions, please. At the back there. There's a mic coming your way. Kimo.
Thank you, Professor.
Yeah,
Hello?
you're on. Yep.
Thank you, Professor. So it seems like a lot of this debate is traditionally over major institutions, OpenAI, et cetera. What about open sourced models? So how, for instance, if I can download Llama 2 on my desktop, it's 20 gigabytes, and then maybe I have to fine tune it so I could just use a basic $1,000 computer to build my own model, publish it on the internet, and anyone can use it anonymously. How is copyright law supposed to enforce the regulations if everyone can just generate these things anonymously on their own localized computer?
Great question. Justin?
Are you talking about how can copyright deal with the outputs of your? Well, the outputs is actually quite easy because while we call it copyright, it's been a long time since we've been in the digital networked environment that what copyright is really controlling is distribution, not reproduction, not production per se. Produce it and keep it on your home computer and no one will notice. Once you start distributing it, you will be found. And if you don't believe that,
And punished.
take a picture of yourself and put it up on TinEye and see how many places your image already appears on the internet.
We have time for one more question. Just one more.
Thank you so much for being here. I had a question about what you think is going to happen with the entertainment industry, especially coming off of this summer's strikes, and sort of what you see the balance that might be had between either side of that argument being.
Great. Pam?
I'm happy to do that.
All right.
So 4 members of the Senate recently introduced a discussion draft to control digital replicas. And now this is outside copyright law, but it's related rights. I think we're at the moment when we can address deep fakes, something we had been trying to talk about for a long time. But now we're at a moment where at least one of the major trade associations that represents content owners and the Screen Actors Guild are working cooperatively. And the Motion Picture Association hasn't said no. And if that can all be worked out among them, right now we're at a moment where the AI companies have enough problems that they are willing to say, okay, yeah, we agree no one should be able to impersonate Tom Hanks or Barack Obama. And so we may be at the moment when we get a federal digital replica law, which is like a federal right of publicity. And personally, I think that would be the best outcome, although there are significant First Amendment issues because you want to be able to make sure that someone can create a digital replica to do a historic enactment of facts or a digital replica in a parody situation. So there's a lot to be worked out. But if you want to find it, it's a discussion draft that's been introduced by Senator Blackburn, Coons, Tillis, and do you know the fourth
I
one?
don't know the fourth one. I just know Blackboard.
Blackburn, Coons, Tillis, and okay, I'm
Somebody
3 of the
else.
4. That's pretty good.
Pam?
It's called the No Fakes Act,
Yes.
in case you're looking for it. And Jennifer Rothman, who teaches at the University of Pennsylvania Law School, has done an extensive analysis of it. And so while she is sympathetic to certain aspects of the problem and deep fakes and the like, she thinks that this bill is really highly problematic. But I think we don't have time to go into those problems.
Let me just add, Jennifer, who's a good friend of both of ours, thinks everything is problematic if she didn't write it.
Oh,
And-
stop it. Justin.
And if you read the web page, her blog, she's highly critical, but then if you read the memo where she wrote in detail to try to actually address staffers, she's not nearly as critical. That betrays political savvy.
On that note, thank you so much to our panelists.